All right, we're back on the record, State versus Loyd. Mr. Loyd waived his presence for charge conference, so he is not present. Let me get the instructions up. All right. Let me start with the jury instructions. Did you do any other versions of these, Mr. Buxman, other than the?
I added the 4 instant offenses under aggravator 2, prior violent felony, to include murder and attempted murder.
Okay. Defense, you have any objections to that?
I also have added the defense mitigators into the instructions. So if I send you what I've done, I've added all the defense mitigators that are going to go through that.
Okay.
Does that make sense?
Yeah, but let me start with the aggravating factors and the addition of the attempted felony murders. Are you objecting to this? Yes. Okay. And then let me look at, you added, yeah, I don't have the one, let me look. Yes, please, thanks. Did you send it? Here it is. I've got it. It's Monday at 10:45 is when you sent it. The original.
I don't remember, Your Honor.
It was Monday morning.
That sounds correct. Monday morning, yes,
Okay.
ma'am.
All right. Thanks. Get rid of all that. All right, so let's just start with 7.11A. Any objections to the aggravating factors section of that?
The only thing I should do is the aggravating factors, where it lists both murders, first-degree murders. That can be confusing because one applies to one and one applies to the other.
Where are you in all of this?
Sorry?
Where are you in all of this?
Under aggravating factors.
Right.
We're number 2.
Okay.
Defendant was previously convicted, and then it does battery of a law enforcement officer, murder in the first degree, killing an unborn child by injury to the mother, attempted first degree murder, attempted felony murder, felonies involving use of threats or violence to another person. And then 3 says the 12 and under only has to count 2. Well, the first degree murder is only as the killing of an unborn child count. And killing the unborn child is only considered first-degree murder.
Yeah. It is a little bit confusing because of the way this works. Yeah.
I can do one of 2 things, Your Honor. I can take out on aggravator 3, the less than 12 years of age, take out as to count 2 only. It's delineated in the verdict form of count 2, and aggravator 3 only applies to count 2 in the verdict form. It doesn't appear on count 1. Under paragraph 2, the prior violent felony, all that says is the court is instructing the jury that these various different crimes, which may be applicable, are prior violent felonies. It's a legal instruction saying that they do qualify as felonies involving use of the threat of violence.
But they're not applicable to.
You can't consider murder in the first degree as to count 1, and you can't consider killing of an unborn child as to count 2. It would be simple to say murder in the first degree, parents as to count 2, killing of an unborn child by injury to the mother as to count 1. Just put it in parents which one they can consider it for. This jury seems to have the ability to follow complicated instructions because they followed the verdict form in the guilt phase.
I have done that, Your Honor.
Yeah, okay. Thanks.
But I put as it pertains to the sentence on count 1, say murder in the first degree as to count 2, but it's really count 1. So should I say as to
You can't consider
consideration of the sentence as to count 2?
2. That's fine.
Okay.
At least that's clear. And then same wording for the next one, for consideration of the sentence as to count 1 for killing of an unborn child. And then leave 3 as it is, because I don't want them to think they can count that as to count 1.
That changes me.
Okay. Any other changes to aggravating factors? All right, mitigating circumstances. I can't hear you. What?
They're all listed there, including catch-all.
And she does not have what I just sent you.
Oh, you know.
So,
I don't have the catch-all. Yeah. Yeah.
I'll email you.
That was, my note was, where's the catch-all on this one? Okay. So let me close this one out. And get the one with the catch-all.
I just emailed you
Okay.
the new version with the changes we just discussed and the listing of the mitigating circumstances.
And there it is. All right, thank you. This doesn't have the change in it. It didn't take. It's okay. I can type it in.
I have it right here.
Okay. Okay, thank you. All righty. So, just make sure I have the one that, I'm sorry. All right, mitigating circumstances. Let me read through this. All right, go back to I'm in mitigating circumstances. Starting with number 1, this is a grammar issue, nothing else. This is how it reads. Among the mitigating circumstances you may consider is the existence of any other factors in Markeith Loyd's character, background, or life, or the circumstances of the offense that would mitigate, et cetera, et cetera. It says,
The mitigating circumstances you may consider is,
because the existence of any other factors implies that I've just given them a bunch of factors, and then I've suddenly started with these. It doesn't make any sense when you read it. So you can say among the mitigating circumstances you may consider is the existence of any factors in Markeith Loyd's character, background, or life, or the circumstances of the offense, because at the very end is the catch-all that says other. Any objection?
I just want to make sure the catch-all is in
The catch-all's at the end?
there. Right.
Right.
So whatever you need to use the front end, make it sound right.
Well, I'm taking out the word other. It would read the existence of any factors in Markeith Loyd's character, background, et cetera. That's number 1. And then at the very end, Q is any other factors in Markeith Loyd's character, life, or background, or the circumstance. It's just more of anything a grammar change. All right, any objections from either party? No. Should we guys
I have a few objections as the actual mitigators itself as far as the
Okay.
formatting.
Let's just get the formatting down, and then I'll get to the mitigators themselves. Let's see. Go down to the defendant exercise a fundamental right by choosing not to be a witness in this case. That is going to completely confuse the jury. He didn't testify in the penalty phase, but he did testify in the guilt phase, and we appear to be directing the jury not to consider that.
Judge, can we go back to number 1
Yes,
on mitigation?
sure.
I was speaking to Sade, and she suggests,
If we just took out number one, we had it saying, among the leading circumstances you may consider is or are, and then list case is you, and then you ways.
Catch all.
So that there's sort of separate factors as opposed to look at the one factor.
So you want it to read, among the mitigating circumstances you may consider is A, Markeith Loyd had a diagnosis of delusional disorder?
Yes.
You want it to start that way?
Yes. And then add the few
Mr. Fexman?
I filed back in February a motion dealing with that very issue.
Yeah.
The mitigator is the existence of any factor in his life. All of the remaining A through Q are subparts to that one mitigator. So that is the Florida Supreme Court case of Brady v. State 111, Southern 3rd, 810. That is misleading. There is one mitigator in this case, and there are a bunch of subparts to that one mitigator.
Yeah. The Brady case, I'm afraid he's correct. This is, the mitigators in this case are not the statutory, well, the only statutory mitigator you have is the catch-all. And if we don't list it the way it's written right now, it appears that we're listing individual mitigators, when in actuality, this is the subparts of, I'm trying to remember how it's phrased in the case, but I'd have to look it up. These are the subparts of the statutory catch-all mitigator.
Brady was reversed. It was actually one of my cases. And we argued for these in court, not allowed
Right.
us to use them. And then that was addressed by Brady's report in that issue. Reverse issue.
Well, yeah, but it was reversed because they didn't let you use the mitigate, they didn't let you specify what all these subparts were.
Right, but it was affirmed.
Right.
And addressed that issue that
Right.
it was reversed on the first issue later on.
Right. But what I'm saying is, it's been a really long day. Brady wasn't reversed because you didn't get to list these out specifically.
Right.
Wasn't this the way they did it in Brady? Doing the catch-all and then the subsections?
I don't think so. I think we raised it.
Brady just did the catch-all, actually.
Well, Brady was more of an argument about how it could be argued. And the
Yeah, I'd have to read the case again. I mean, it's in the back of my mind. I know that it exists and that this looks right to me. Sure. Thanks.
it's on page 29.
Thank you. Since you have extra copies for the record, I'm assuming you have one for the defense. All right, let me see.
The RAPD one.
Okay, yeah, I remember this. I think it's correctly stated the way it is now. So I'm going to deny the defense's request to take out number one completely. I'm going to leave it the way it is. Since we're in the mitigators, I may as well listen to the state. You are objecting to some of these. Which ones are they?
Mitigator A, I think should read Markeith Loyd has a diagnosis of delusional disorder, period. I think to further expand on what delusional disorder is, before you comment on the evidence, it's not the appropriate place to explain what it is. Mitigator is the has delusional disorder, or not.
Response?
Good, I changed my mind. I'm now requesting that all mitigating factors be removed from the verdict form with the exception of catch-all and agree with the jury instructions.
So the defense does not want them individually listed in.
You don't want them listed out individually.
Okay.
But just for record purposes, you intend to argue them, is that correct?
Of course.
Okay.
Oh, yeah, I'm arguing with them. I don't want to have to, yeah.
Okay, so it would now then read, among the mitigating circumstances you may consider is the existence of any factors in Markeith Loyd's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty, period.
Is there some language that references the case?
There may be. I got to pull up the,
References
The case.
to. Well, it says the incident offense. The existence of any factors in Markeith.
or the circumstances of the offense
Okay, that's perfect.
that would mitigate against the imposition of the death penalty. So then there would be a period, and everything under that would be deleted, including Q.
Perfect,
Is that what you want?
correct.
Okay.
And the same thing with the, that's the one thing I
Well, I wasn't, I lived through, no, I have post-traumatic stress from the verdict form in Rosario, which read like that one. I'm not doing that again. All right. So, here's how it reads. Among the mitigating circumstances you may consider is the existence of any factors in Markeith Loyd's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors, and then it goes on from there. That's how you all want it to read. Okay.
There's no numerical or rather it's just.
You want me to take out the one?
Yeah.
Okay. You can do that. Okay, moving on. Let's get to this. The defendant exercised the fundamental right by choosing not to be a witness in this case. He did testify in the guilt phase.
Yeah, I think we should.
I don't think we should put this in there because it seems to be instructing them to disregard anything he said in guilt phase, which is incorrect. So the normal thing to do at this point is say the defendant became a witness in this case. You should apply the same rules for consideration of his testimony that you do to any other witness. That's the standard instruction for defendants testifying.
Right,
Would it be more appropriate to put it in an exercise of fundamental right by choosing not to be a witness in the penalty phase of this case? That way you can cover both things.
my concern is that,
Yeah.
yeah.
That was going to be my next question, but that only covers guilt. Then he did not testify in penalty phase, and I don't want them to read anything into that.
I agree, I think we should be, like others talking,
So you want it to be the defendant exercise a fundamental right by choosing not to be a witness in the penalty phase. Now, what are you going to do about, because the rule is, well, I guess my question is, are you going to argue his testimony in the guilt phase? Because then it's subject to the same rules as every other witness. I don't have a problem reading both instructions, telling them he exercised a fundamental right in the penalty phase and you can't do anything with that. In the guilt phase, he chose to testify and you can, evaluate his testimony. I just spewed it out. I have it memorized, but now I can't remember it. What? I don't have a problem with both paragraphs, just being very certain that we tell them in the penalty phase, you can't use his silence. In the guilt phase, you treat him like you evaluate like any other witness.
I agree.
No objection, Your Honor.
Okay, so let's add that one back in again. I added it somewhere and now I can't find it. You must know jurisdiction. Okay. So then the other one is the defendant has become a witness in this case. The defendant became a witness in the guilt phase. this case, you should apply the same rules in evaluating his testimony. You better check my my memory. Let me finish typing it out and then read it out loud, because sometimes I do it and then I don't like it.
I'm just concerned that it becomes a concept for the aggravator, because, if they consider some of the things he said that don't fall into the aggravating factors, like the fact that, let's say, they believe he's lying about the events. I mean, that the instructions seem to say that they can use that in some form of fashion. That's not true.
Well, if they believe that he was not truthful in his testimony, they would be able to use that in evaluating whether or not the diagnoses which the experts gave are accurate. I mean, they can use his testimony in the guilt phase in evaluating whether they find the witnesses in the penalty phase credible.
Right. The testimony that came from our witnesses was, number one, psychosis is not always present. Number two,
Right.
none of our experts opinionated that there was psychosis present during his testimony. The only one who said that was their expert.
I don't have any strong feelings about this one way or another, in all honesty.
I just think we should leave it to the penalty phase and look at the penalty phase, not say either one.
I have no opinion on this one at all, Your Honor.
Thank you, Mr. Buxman, that's very helpful. All right, I'll take out the defendant became a witness in the guilt phase. So it reads, the defendant exercised a fundamental right by choosing not to be a witness in the penalty phase. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. We need to change that to penalty phase so that it's all consistent. Well, let me ask a question before we get off this subject. And I'm more concerned about what the jury not getting confused. Are either of you planning on arguing or using the defendant's testimony in the guilt phase in any way in your closings in the penalty phase? Who's doing closings? Are you doing?
I would only anticipate sort of tangentially in talking about the experts and their opinions and what they said.
Okay.
If I thought that there was some contradiction from the defendant's own words, I would probably point that out, but that would be the only thing I see that I would argue.
Mr. Loudman?
Yeah, I mean, I clearly am going to talk about his testimony, but you saw the way where I think for the voters, there is a witness. So,
Well, I understand that, but the issue is not whether you maintain credibility in terms of these jury instructions. The issue is if you all in closing are referring to the defendant's testimony, but we're also telling them that he didn't take the stand in penalty phase, we're giving them instructions about how to evaluate everybody else's testimony. Most of these witnesses did not take the stand in penalty phase. I mean, it was a whole new set of witnesses in penalty phase. But if you're going to start talking about detectives or any of that, then it's going to become extremely confusing for the jury. You see what my concern is? I'm not trying to limit anyone's closing in any way, shape, or form, but I am trying to make sure the jury understands how to evaluate the testimony as a whole, both guilt and penalty.
yeah, I just don't see really getting too far field on what happened.
I mean, we're reading the paragraph about testimony of some witnesses with more caution than others because of Mr. Struby, who did not testify in the penalty phase.
I'm not going to
Correct.
I'm not getting into that
So then why am I reading this paragraph?
This paragraph.
You may consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case. If no one's going to address Mr. Strube, we need to take that paragraph out, because all that's going to do is cause mass confusion. All right. Do I have any objection to removing this paragraph? Any objection from state? All right, let's take that one out then. Let me go through this with a fine-tooth comb. I just do not want this jury getting confused. I mean, we have, had the witness been offered or received any money, preferred treatment, or other benefit?
Oh, yeah.
That was what?
All experts were paid.
Oh, that's right, okay. Has any pressure or threat been used against a witness? That doesn't apply in this. So let's take out 7. Did the witness at some time make a statement that is inconsistent?
Yes.
Somebody did something with impeachment. Has the witness been convicted of a felony? If we're not going to talk about guilt, we need to take this out. And we're not going to talk, what?
I think at least one of the defense witnesses indicated they had a felony conviction.
You did? Okay. Does the witness have a general reputation for dishonesty or truthfulness? We didn't have any of that. All right, so let's take that one out. I mean, if this can read mostly like we're talking about the penalty phase witnesses, the fact that a witness is employed in law enforcement.
We had 2 law enforcement witnesses testified.
You did? You can take out the, many of you may have cell phones, tablets, laptops, since I confiscated all their electronics. You see the paragraph I'm talking about?
Yes, sir.
Thanks. All right.
Or the exhibits received evidence, should I change that to say some of these exhibits will be sent?
Yes, because I'm not sending, yeah, the weapons aren't going back. There should be a paragraph at the end of the, please disregard anything I may have said or done that made you think I preferred one decision over another.
That is, start like not just getting deliberations anyway.
Right, and then the next paragraph should be, if you need to communicate with me. All right, any other changes to these instructions?
Not from the state, right?
Do you have any other changes as to the instructions themselves? All right, verdicts. Oh, yeah. Oh, yeah. I'll tell you the story of the other 4 when we're done here today. All right, so any objections to the standard form that's attached to your verdict as to count 1? So we have 2 aggravators. Defendant under sentence of imprisonment or community probation and previously convicted of a felony involving the use of threat or violence.
That's count 1.
What? That's 1. Count 1, yeah. I'm just doing count 1 right now. All right, verdict as to count 2, we have 3 aggravators: probation, the bat Leo threat or violence, and the unborn child was a person less than 12 years of age. Is that how it reads? Was a person less than 12 years of age, or was less than 12 years of age?
It says a person less than 12 years.
It says,
Hmm.
L says the victim of the capital felony was a person less than 12 years of age.
Okay. I just printed the verdict form, so I want to see what they look like. Okay. Anything else on the verdict forms? Okay. Anything else we need to discuss before tomorrow?
We just email this to us.
I'm doing that right now.
Oh, I was gonna say, please tell me it's not another note.
Sent, like, had all the changes in it around everybody. I sent it to everybody what I hoped all the changes that we talked about over there. Court gave copies of these to each juror as well.
Yes.
I'll remove the preliminary instructions and get copies of sentencing letter, not including the verdict forms.
Right, I have the verdict forms up here, I already printed those things. And I'll go ahead and read this, I'll read it to them in their entire, well, I'll read aggravating factors, mitigating factors. I'm going to stop at the end of, it's 3.10 actually. I'm going to stop where it's on page 9. Your decision must be based on the evidence and the law contained in these instructions. I'll let you all do your closings then, and then I'll read the rest of it, which starts with, in just a few minutes, you'll be taken to the jury room by the court deputy. Again, so they have this in, I've read it to them, and they have it in front of them before you do your closings on the penalty phase. Okay?
It all should be attached to the
Yeah, I'm just reading it to make sure there's no problem, since I didn't spot the others until the middle of reading the other ones. Okay. See you guys. I think we're done. I'll see everybody. Yep.